Just waiting for confirmation, giving everybody a few moments just to get logged in and get their audio. I've gone ahead and muted everybody just so, like last time, we can get through these proceedings quickly. Whether you agree or disagree with anything that's said or what the board of directors' decision is tonight, we'd ask you just to be respectful, stay on mute. There will be time for any rebuttal through your owner's representative, through any DBPR action that may be necessary. So just please be respectful tonight. I know it's a very contentious issue. All right, I do see we have a quorum of the board. You have all active board members on the line, so I can confirm. Quorum is accepted. Do I have a motion to open the meeting from one of my directors? Motion to open. Second. Janelle, do you second? Yes, I second. Okay.
I do have an objection to who is.
Oh, yay.
I do have an objection to who's chairing the meeting here.
Your objection is noted. Okay. I understand the board of directors, the intention for tonight is to do a rejection of the recall as presented. I understand Director DJ is going to be reading the reasons into the meeting minutes for official purposes. If you give him the floor, he's going to provide the reasons prior to the motion.
Before we get there, Florida Administrative Code Route 61 dash.
I'm not going to.
No, you're not a neutral party in this. You don't get to commandeer, and you didn't answer any of my questions regarding who's chairing the meeting. So you've intentionally.
DJ, if you could proceed.
You're not going to mute me either.
I will remove you from this meeting should I need to.
Will you? And you'll have a legal action against you.
That's fine. DJ, please proceed. DJ, are you there? DJ, make sure you open your mic.
For the record, I've asked Carlos Garcia, the Secretary of the Corporation, to chair this meeting. I was ignored by legal counsel, did not respond to any emails, nor did any board member on this call. The only neutral party is the Secretary of the Corporation. Sarah Webner is not a director on the board. And clearly, we do not have a director on the board ready to conduct business. How can you have a quorum
Stop.
if you do not have members?
Take
roll call.
Legal counsel.
You can take roll call because obviously he's not here. This is not a quorum if people aren't telling you that they're there.
I see that DJ is unmuted. DJ, are you able to? Oh, perfect. Okay, good. Okay, are you able to read into the record the reasons for denial?
Yes, I am.
Okay, perfect. Thank you.
Reasons for rejecting the ballots. Number one, premature and duplicative filing. The filing of a second, nearly identical recall effort while the first is under review is both procedurally unnecessary and procedurally disruptive.
That's not a legal reason.
This duplicative filing circumvents the existing arbitration process and undermines the division's authority to adjudicate the original matter fairly and efficiently. Procedural posture of Florida Statute 720.303. However, pending ruling with DPPR is whether the association is bound by the changes in 720 or whether the bylaws of the controlling and operative document. At
I have no clear audio
these
from
ballots
DJ.
do not comply with the reading. Number two, improper conduct in petition circulation. Florida law prohibits fraudulent misrepresentation and undue influence in gathering, recall, or initiative petition signatures. The first and second recall effort have been accompanied by undue influences with numerous false, defamatory, and misleading statements that materially misrepresent of the facts and the laws governing Florida homeowners associations.
Like the QR code that was sent by the president to all homeowners? Anybody get a QR code?
By way of example, the board has not refused reimbursement to Director Davis. The board has not misused funds, including bonuses to management. Board members have not caused damage to common area. The board has not engaged in criminal activity. Notably, there was an email to all homeowners distributed on June 4, 2025, just days before the initiation of the second recall petition signatures on June 8, 2025, regarding accusations of criminal activity. After a full review by law enforcement, the matter was dismissed with no action taken. Once the board president supplied the complete and accurate documentation to the investigating officer. Statements that owners have caused reputational harm to board members and created unnecessary alarm among homeowners. On June 11, 2025, the investigator stated that the case was closed in a phone conversation with Scott Davis. Despite this, the owner representative continued to claim on June 27, 2025, that an investigation was ongoing.
The investigation is ongoing, not with Orange County Sheriff's Office, being referred from DBPR to OCSO.
Baseless legal accusations of criminal activity. Owner representative has publicly and repeatedly accused board members of engaging in criminal conduct, including violations of federal, civil, and criminal laws. These accusations made through YouTube, a personally operated website, emails, and verbal statements are factually baseless and appear to be calculated to undermine the credibility of board members.
Board members did that to themselves.
And reflect a gross misinterpretation or deliberate distortion of the statutes and rules governing Florida HOAs under Chapter 720. Under Chapter 720 Florida Statutes, no such violations have occurred, and no competent historian has made any such findings. These serious substantiated claims appear aimed solely at intimidating board members and misleading the community.
Board members didn't vote on their own recall. They were voted out by homeowners.
And Janelle, help me with the last part of this. I know ballots did not go to everybody. So
They don't need to. You don't understand the process.
The original ballots did not select replacement directors. And
that was a different recall.
Only selected 3 replacements.
Hey, DJ, I'll help you there.
Hey, DJ, thank you for letting everyone know this is a distinct and different recall process, clearly outlined by the Declaration of Independent Written Recall Action.
The ballots as tendered in the second recall. There are 4 addresses that I'll read off where replacement directors were not selected. That is 2102 Churchill.
Replacement directors do not need to be selected by law, only the recall of the original directors. No one needs to vote. No one needs to vote on replacement directors. No one needs to vote on replacement directors. Do not need a vote by law.
Contain yourself.
If you cannot,
meetings, you will be removed.
You're going to remove the vice president.
Yes.
That will be on you.
Contain yourself.
Stop spreading misinformation. They do not need to vote on replacement directors. They can vote on recall only and not be participating in the replacement director vote. That is legal.
Noted your objection. It's a reason that they're writing it in. At this time, do I have a motion to reject the recall based on the statement provided, directing counsel to file for the association a petition with DPPR and authorizing the attorney's fees related to all matters?
No, you don't get to vote on your own money income at this point. This is not part of it.
Do I have a motion from one of my directors?
This is not part of. You don't get to vote on your income right now. This is inappropriate use of this meeting.
Okay, we have a second. Do I have any objections to the motion?
I object if I'm not going to be muted during my objection, which I've been muted about 15 times already by Sarah Webner, who is not acting on behalf of the association. She's acting on behalf of the recalled directors.
Corporate counsel style.
Why haven't you responded to my email? Am I not part of the board of directors? Carlos Garcia said he'd not receive anything from you either regarding who's chairing the meeting. So the directors not subject to recall are the ones not being communicated with, for the record.
No, I haven't communicated with anyone. I haven't seen your email.
The written recall package here is a new, independent, and statutory distinct recall action, not a continuation, extension, or consolidation.
Can I have an aye from each of the directors that are voting?
This is where they're trying to vote to send money to Webner. This is inappropriate.
Aye, Tom Franzen.
I have an emergency.
Aye, DJ Johnson.
I have emergency requests with DBPR right now in process. He has not responded yet. This is inappropriate.
DJ?
This will be forwarded to DBPR.
Aye.
Okay. Erica, you were an aye. Carlos, did you abstain again?
Look at this racket.
No.
You vote no?
Correct.
Okay. And Scott, you vote no. The motion carries by a majority of the board.
Let the record reflect directors not subject to recall all voted not.
That'll be reflected in the meeting minutes. Thank you.
The meeting minutes that you will provide or the secretary will provide. Because last time you sent to DBPR, those were created by you, the attorney, not the secretary and director on the board. Is that appropriate for you to commandeer the secretary's director position and make the minutes according to how you want them read? Is that appropriate? Or should the director be responsible for his own position on the board?
Thank you, everybody, for attending this evening. We appreciate your time. We'll be in touch and let you know the outcome of the arbitration.
It gets worse and worse for you guys.